Welcome to Workshop 12. We're going to be exploring the various issues around the rights of the child with specific learning difficulties in this workshop. This session will aim to explore the rights of the child with specific learning difficulties with respect to current legislation, discuss the Additional Learning Needs and Education Tribunal Act, or ALNET, which has just recently been passed in Wales, and how the ALN Draft Code of Practice relate to children and young people with SPLD. We're going to look at the ladder of participation and the role of the adult, and that's particularly looking at the amount of power and control adults have compared to children in this sort of situation, and also think about that in the context of how we do things in Wales and how we're moving towards doing things in Wales through things like individual development plans. Part 1 of this workshop is going to focus on current legislation and also take a little look at disability and discrimination law. The Special Educational Needs Disability Act, or SENDA, was passed in 2001, and this act places a legal duty on schools to meet the needs of children with disabilities and furthermore to outlaw disability discrimination. It made schools responsible for ensuring that disabled pupils were not treated less favourably without justification in both their physical and curricular access to education, and for preparing accessibility plans that would be available for inspection. SENDA made it unlawful for schools to discriminate against a pupil who was disabled in the arrangements it made for determining admission to the school and in the education or associated services provided. There was a requirement on schools to make reasonable adjustments so that pupils with disabilities could attend. These duties were anticipatory, and that is, schools or other education providers would have had to think ahead and consider what they might need to do before problems arose. SENDA gave a wide range of legal rights to children with disabilities for the very first time, and these rights were then strengthened by the Disability Discrimination Act in 2005. The Disability Discrimination Act in 2005 was an amendment of the earlier Disability Discrimination Act of 1995. It introduced the Disability Equality Duty, which set out a general duty to promote disability equality, and a specific duty that included a requirement to prepare and publish a disability equality scheme, which showed how the school was meeting its general duty. The general duty required schools to promote equality of opportunity between disabled people and other people, eliminate discrimination, eliminate harassment related to disability, promote positive attitudes towards people with disabilities, encourage participation of disabled people in public life, and take steps to meet disabled people's needs even if it required more favourable treatment. The Disability Discrimination Act applies not only to pupils in schools, but also to members of staff with a disability and to parents of other users with disabilities. It required schools to be proactive in collecting relevant information and promoting equality. An example of this might be for schools to contact parents of children with disabilities who do not regularly attend parents' evenings to find out if there's a problem that the school could resolve, such as providing a creche for the children whilst the parents talked to teachers. So is dyslexia a disability? From October 1st in 2010, disability discrimination issues became covered by the Equality Act. This replaced the Disability Act of 1995 and 2005. The Equality Act provides a single source on discrimination law, which covers age, disability, gender reassignment, marriage, civil partnership, pregnancy, maternity, race, religion, beliefs, sex, and sexual orientation. These are referred to as protected characteristics in the Act. The Equality Act legally protects people from discrimination in the workplace and in wider society. Disability discrimination legislation prohibits discrimination against disabled people in employment and in the provision of goods and services, and this includes education. An implication for education is that it is unlawful for schools to discriminate against, harass or victimise a pupil or potential pupil with a protected characteristic. In relation to admissions, in the way it provides education for pupils, in the way it provides access to any benefit, facility or service, and or by excluding a pupil or subjecting them to any other detriment. Section 6 of the Equality Act defines a disability as having a physical or mental impairment which has a substantial and long-term adverse effect on your ability to carry out normal day-to-day activities. The Act goes on to say, in some cases, people having coping or avoidance strategies which cease to work in certain circumstances. So, for example, where someone has dyslexia, is placed under stress, their dyslexia may cause them more problems in that context. If it is possible that a person's ability to manage the effects of an impairment will break down, so that these effects will sometimes still occur, the possibility must be considered when assessing the effects of the impairment. And so here we do come to the conclusion that dyslexia is classed as a disability in particular contexts. Dyslexia is included as a disability under the definition of impairment, within a wide range of other impairments ranging from sensory, progressive and learning disabilities. Dyslexia itself is grouped in the developmental category along with autistic spectrum disorder and dyspraxia or developmental coordination disorder. Because of the legal definition of disability, only adjudicated bodies can determine whether a person would meet that definition. This can be difficult if children aren't having statutory assessments or full diagnostic assessments to actually give them that particular label. And so any parent who is struggling for this may be tempted to go and seek private assessments to get the proof that they need to challenge the local authority on a legal level. SNAP Cymru are a really helpful organisation who can support parents and give them some independent advice as to what type of support they are actually entitled to for their child and how best to get that support put in place. Discrimination, as defined by the Equality Act of 2010, can come in four different forms. Firstly, there's direct discrimination, there's indirect discrimination, and then there's also harassment, and finally victimisation. Pause the presentation now and click on the YouTube link below for a short. The Equality Act highlights the needs for schools to be proactive in making reasonable adjustments. It states that they have a duty to make these reasonable adjustments where a provision, criterion or practice puts a disabled person at a substantial disadvantage. A physical feature puts a disabled person at a substantial disadvantage, or a disabled person would, but for the provision of an auxiliary aid, be put at a substantial disadvantage. Educational settings must comply with the first and third requirements, and the second is already part of the school plan. They also have a duty to take such steps as are necessary to avoid the disadvantage. Not to make these necessary reasonable adjustments could result in indirect discrimination, which is unlawful. Unlawful behaviour covered by the Act also includes harassment and victimisation. Harassment is defined in the Equality Act as unwanted conduct related to a relevant protected characteristic. Unwanted conduct might be described as conduct which has the effect or purpose of creating an intimidating, hostile, degrading, humiliating or offensive environment. So this covers behaviour such as bullying, but potentially extends to action which intentionally or unintentionally causes offence or intimidates a person, such as making derogatory comments about a person's spelling ability or the presentation of their written work, for example, or asking a learner with dyslexia to read aloud in front of peers without checking with them that they're happy to do so. If a practitioner belittles a child because of a disability, this could lead to prosecution for unlawful harassment. So what are schools required to do? Under the Equality Act, schools are required to have an accessibility strategy for improving the access of learners with disabilities, and this must be in writing. The accessibility plan should increase the learners' ability to participate in the school curriculum, increase the extent to which they can take advantage of education and benefits, facilities and services, and improve the delivery of information to disabled pupils. Schedule 17 of the 2010 Equality Act sets out disabled pupils enforcement, which is the right to take disputes to a special educational needs and disability tribunal. This is when a claim is made to the tribunal by a parent within 6 months of the date from which when the incident occurred, claiming that a responsible body has contravened Chapter 1 of Part 6 Education in the Equality Act because of a learner's disability. If the tribunal finds that a contravention has occurred, it has the power to make an order as it thinks fit with a view to reducing the adverse effect on the person making the claim, but it cannot offer any payment of compensation. In addition to disability discrimination, until 2014, this tribunal dealt with appeals against special educational needs decisions. In part 2 then we'll be looking at the current policy and legislation in Wales, and that's just something that's been updated very recently and is still really evolving and being put into place. We'll briefly first look at the Code of Practice in 2001 and in 2002 for Wales, just to sort of give that background as to how the system was currently working up until very recently, and also look at the SEN Code of Practice that's been put into place more recently in England, because there's some comparisons there. And then we'll take a closer look at the ALNet, which is basically informing how we move forward with additional learning needs and supporting children. We'll take a brief look at current legislation and policy in England. There have been some recent changes and a new code of practice. These were all brought about by initially a green paper, which is a tentative document putting forward proposals as to how and what type of changes were needed surrounding the issue of children with special educational needs and disabilities. And this led to the Children and Families Act being passed in 2014, which then led to the SEND Code of Practice, which is the guidelines and guidance as to how to implement this new legislation. So this Code of Practice is slightly different from the one in 2001. So instead of statements, there would be something called an Education, Health and Care Plan, an EHC. Another big difference is that the age range which this covers is 0 to 25, so we're looking at much older, a much broader age range, and that's partially because one of the key focuses of it was looking at how these individuals transition into adulthood, so it is offering more support for children up to the age of 25. And they also have something called a local offer, which is basically a publication within each local authority of what type of support is available for children with special educational needs and disabilities. And this is to provide a more transparent approach to what's actually available for children. And there's very much a focus in this new Code of Practice for involving children and parents in decision making and working together as a team, as well as more multi-agency working. And so we come to current legislation and policy in Wales. The Additional Learning Needs and Education Tribunal Act came into being on the 24th of January 2018. Following consultation with stakeholders, the Welsh Government has adopted a phased approach to implementation. It was going to be from September 2020, but obviously we've had COVID pandemic since then, and so it's now proposed it will be more like September 2021. So from this date, learners who are newly identified as having additional learning needs will be supported under the new arrangements, while learners from the existing system would transition to that new process over a 3-year period. There are 3 overarching objectives to the Additional Learning Needs Education Tribunal Act. There's a new statutory framework which will support children and young people with additional learning needs from birth until the age of 25, as the one in England does. And again, this is instead of having 2 separate systems, a pre-16 and a post-16, which there's separate legislation currently, or before this comes into effect. There's actually 2 separate pieces of legislation attached to the different age groups. Secondly, the Act would promote an integrated and collaborative process of assessment, planning and monitoring, which facilitates early, timely and effective interventions. This would include duties on health boards and local authorities to collaborate with each other through statutory individual development plans for each learner with additional learning needs. The third overarching objective is a fair and transparent system for providing information and advice, and for resolving any concerns and appeals. This includes requiring local authorities to make arrangements for avoiding and resolving disagreements, and revising a system found by previous review to be a little bit too complex, bewildering and sometimes adversarial. There are a number of core aims within each overarching objective. Core aim 1 to 3 relate to the first overarching objective, Objective A, which is a unified legislative framework. Core aims 4 to 5 relate to the overarching Objective B, which is to have integrated collaborative processes with early, timely and effective intervention. Core aims 6 to 7 are linked with the overarching Objective C, which is having a fair and transparent system. I'll give you a brief outline for each core aim, but if you're interested in reading more about it, there is a summary available in the further reading section, where it's referenced at the end of this lecture. The first core aim is the introduction of the term additional learning needs. This replaces the existing terms of special educational needs in pre-16 education and learning difficulties in post-16 education. Its definition is essentially the same as currently used for both SEN and learning difficulties. A child or young person is considered to have a learning difficulty or disability if he or she has a significantly greater difficulty in learning than the majority of others the same age, or has a disability which prevents or hinders him or her from accessing education that is available to others their own age in mainstream education. At present, a person will not be considered as having a learning difficulty solely because the language spoken at home is different to the language in which they're taught, nor would they be deemed as having ALN if their lack of progress or difficulties could be addressed through regular differentiated teaching. Children and young people who have dyslexia are considered as having additional learning needs, as they require more support than just regular differentiated teaching. The Welsh Government envisages the same number of learners will be deemed as having ALN as those with SEN and LDD at present, as a result of using the same definitions. However, it believes that using the same term for all learners aged under 25 provides greater equity and underlines the coherence of the new system, using the same term throughout their education. It's also believed that the newly established term ALN will reduce stigma and mark a clear break from the previous system that was in need of fundamental reform. There will be one type of plan for all learners under the new system, all learners from 0 to 25, which is called the Individual Development Plan, or IDP. This plan will be the same plan for all learners with ALN, regardless of their severity. The current distinction between a statement, school action, and school action plus will no longer exist. Instead, all learners with ALN will have statutory IDP, as will learners with ALN aged 0 to 25. There will be a distinction between the more severe and complex cases, where local authorities will be responsible for maintaining the IDP for the most severe cases, and the IDP will be the responsibility of the school or further education institution for the less severe and complex cases. The fourth core aim is to ensure increased collaboration between different bodies and organisations. This is possibly the most important aim of the Act and the new developments. It seeks to ensure that local authorities and health bodies work together in the best interests of the learner. This was previously one of the areas that generated the most concern in the Welsh Government's consultation on the draft bill. Previously, there were insufficient duties on the NHS to secure their involvement in supporting learners with ALN. This has led to the requirement for a new role within the NHS, that is the Designated Education Clinical Lead Officer, or DECLO. This must be a member of staff who is a registered medical practitioner or a registered nurse or another health professional. Core Aim 5 is high aspirations and improved outcomes. This aim requires local authorities to keep under review the arrangements for supporting learners with ALN within their areas to consider whether these are actually sufficient. According to Section 60 of the Act, all mainstream maintained schools, including maintained nurseries and PRUs, must have a designated Additional Learning Needs Coordinator, or ALENCO. Currently, it's actually a non-statutory requirement to have a SENCO, even though most schools do have them, but now it's going to be mandatory that everybody has an ALENCO. Special schools are exempt from this requirement, as every staff member is expected to have a focus on additional learning needs. The ALENCO position will replace the existing SENCO role, which, according to the Welsh Government, is interpreted differently across settings and authorities, which was obviously a bit of an issue previously. Section 60 also confers power on the Welsh ministers to make regulations prescribing the required qualifications and/or experience a person must have to be an ALENCO. And how this will currently look is obviously still to be decided. The sixth core aim is to develop a simpler and less adversarial system. By introducing the IDP, the Welsh Government believe that this will create more equity in the system, as the tiered system of school action plus and statementing has been removed. There will also be a requirement on local authorities to make arrangements to provide impartial information and advice about the new system. Core Aim 7 is about avoiding disagreements and earlier disagreement resolution. The Act requires local authorities to make arrangements for both avoiding and resolving disagreements between the child, young person and/or parent and school, college or local authority. This includes providing access to help in resolving a disagreement from an independent person. Local authorities are also required to make arrangements for independent advocacy services in order to provide advice and assistance to a child or young person for whom they're responsible, including the option of representation. So, for example, again, we think about somewhere like Snap Cymru providing advice services. Core Aim 8, clear and consistent rights of appeal. This is about the provision for a child and/or the parent or a young person to appeal about the way a local authority or a further education institution governing body has responded or failed to respond to their additional learning needs. In January 2015, the right of the parents and carers to appeal was given to children and young people in maintained schools themselves. The Act extends this to children and young people with ALN up to the age of 25 who are in further education, thereby establishing greater parity between those in further education and those in school sixth forms. Core Aim 9 is looking at having a mandatory code of practice. Now, recently had been gone out for a second consultation last year, but unfortunately, and it was due to be published in December 2019, unfortunately we have not actually received anything other than the draft code of practice, which is still in place. It's yet to come into effect. So hopefully this is now available to look at as a draft, but the finalised product is not yet available. The 10th core aim is to increase participation of children and young people. This is about developing a person-centred approach, which means that young people and children need to be involved in all aspects of their learning, and that their views, wishes and feelings are listened to, and they actually should be at the heart of all decision-making processes. The final core aim is a bilingual system. This requires service providers to consider whether provision for a learner's ALN should be made in Welsh, and if so, all reasonable steps must be taken to secure those provisions in Welsh. This is quite an interesting one when it comes to dyslexia provision, because there's not quite as many resources and specialist teachers who are actually fluent in Welsh, and so this is an interesting aim. And could be quite a challenge in many respects. So we come to part 3 of this workshop, where we really focus in on participation. So what is participation? What do we mean by participation in the process? Hart in 1992 suggests that the participation is the process of sharing decisions which affect one's life and the life of the community in which one lives. The Welsh Assembly Government in 2011 suggests participation is about children having their voices heard when decisions that affect their lives are being made and being actively involved in the decision-making process. So participation is talking, thinking and deciding. But Alderson in 2008 highlights that participation is often reduced to being consulted and making decisions, and this is usually with adults who are actually in control of the situation. So for example, they may choose the questions to be decided upon and control the process of deciding. The success of participation is therefore seen to depend on the process of how far adults allow children to contribute to, influence and perhaps actually make decisions, and the outcome of how far decisions are acted on, which would be mainly by adults. So at what age is it appropriate for children to be involved in decision making, or what age should they be participating in these decisions and this process? The UNCRC recognises that diverse childhoods exist and children may actually acquire different kinds of competencies at different ages, so it's very difficult to put a particular age on this. Again, the needs of the child may sort of impact on how well they're able to articulate their feelings and thoughts about decisions being made. Children's understanding and competence, again, may just depend more on their experiences, perhaps their culture and also their family life, than on a physical age. An interesting point, just a bit of an aside, is that something like GDPR, which is data protection, that all comes into effect at the age of 13. Any child 13 and over has to give their consent for data about them to be stored, and that's the age at which that happens, which again is quite surprising to some people because that does seem a little bit younger than we might imagine. Again, because children will have all of these different individual needs and difficulties and abilities themselves, they require varying degrees of protection, participation and opportunity for that autonomous decision making in different contexts and across different areas of decision making. It's not a simple process by any means, and it's about striking a balance between protecting that child and guiding them towards what you as an adult feel would be good for them, but also respecting the child's autonomy. You don't want to be in a situation where you're providing too much support, but you certainly don't want to be providing too little adult support in helping children to make these decisions and participate in the process. You don't want to be helping children too early or too slowly, and you don't want the child's and the parents' and other people's rights you don't want the balance to tip in any one particular direction. You want to be able to incorporate and balance out all those different rights, interests and welfare. The UNCRC state that parties should assure children who are capable of forming their own views the right to express those views freely in all manners affecting that child, and the views of the child being given due weight in accordance with the age and maturity of the child. So, for example, a 5-year-old, we would incorporate some of their own decisions and feelings, but perhaps we would not give them as much weight as a 13, 14-year-old, for example. But the freedom of expression for children also involves their right to be informed, and so we do need to make sure that the children can make those informed choices and decisions by having all the necessary information. And that's where we might start to feel like we wanted to protect them from some of the necessary information, but actually we need to consider whether that's the right, we're striking the right balance there. Hart in 1992 developed the Ladder of Participation, which was based on an investigation of participation projects sponsored by UNICEF. These were programs for street children or preventions programs, and he developed an 8-stage ladder based on the previous work of Einstein in 1969. This ladder of participation differentiates between non-participation and participation. And you can see here is a diagram. So the bottom 3 rungs are classed as non-participation. So there would be manipulation, where children do or say what adults suggest they do, but they have no real understanding of the issues, or perhaps children are asked what they think. Adults may use some of their ideas, but don't really tell them what influence they have on that final decision. Number 2 would be decoration, where children take part in an event, but they don't really understand the issues involved. Or tokenism, where children are asked to say what they think about an issue, but really have little or no choice about the way they express those views or the scope of the ideas that they're able to express. Okay, so then the higher rungs on the ladder of participation would be looking at different levels of participation. So number 4 being you'd be assigned but informed. So adults would be deciding on the project and children would volunteer for it. And the children understand the project and know who decided they should be involved and why. And adults would respect the child's views. Number 5 would be consulted and informed. So this project, for example, would be designed and run by adults, but children would be consulted. They would have a full understanding of the process and their opinions are taken seriously. Number 6 would be adult-initiated shared decisions with children. So adults would have the initial idea, but children would be involved in every step of the planning and implementation. Not only are their views considered, but they're also involved in taking those decisions. Number 7, we've got the child-initiated and directive activity. So where the children have the initial idea and decide how the project is going to be carried out, and adults would be available but do not take charge. And at the very top we have child-initiated and shared decisions with adults. So this is where children have the ideas, set up the project and invite adults to join with them in making decisions. So we may think of different school-based activities for this ladder. We might think about where does the current IEP process fall on this ladder? Where do things like entrepreneurial projects that children may partake in school, where would they fall on this ladder? And the point with Hart's ladder is that it's not actually about climbing up the ladder from previous rungs or stages. Each stage is actually seen as a discrete stage. You'd fall on that stage wherever you fall along that ladder. So different activities may fall at different points on that ladder, but it's not a progressive ladder that you would look to climb up. So there have been some criticisms of Hart's ladder. Further research in 2015 only really found 3 groups of participation rather than 8. So this would be sufficient participation, symbolic participation and deficient participation. So a much sort of clearer way of categorising the different types of participation with just 3 options. And it's also been criticised for being rather adult-centric and possibly over general as well. So rather than just recognising children as mainly targets of change, efforts and services, policymakers, researchers and professionals must treat them as partners in change. And I think this is very much what the sort of code of practice, the new guidance, will be looking towards when developing things like individual development plans, which we'll now look at in a little bit more detail. So part 4 of this workshop then looks more closely at the individual development plan. When we're looking at the IDP, this is what we will be replacing the School Action Plus and statementing process with, that we're currently using that system, but there's a move towards using individual development plans, which covers all of those different levels of support. The SENCO or ELENCO would have responsibility for maintaining and reviewing the IDP, and it's created and agreed with by those people working most closely with an individual child or young person, including the parents and carers and the child themselves. An IDP would be created as an alternative, as I said earlier, to those different levels of support, and they would also look at covering that broader age range of 0 to 25. So this does help slightly older children who need ongoing support as they move out of school and into further education, work or continuing care. It also stands for children with more complex needs from birth to school, and they would currently come under the Early Support Initiative. So it's kind of a one process for all different children with different types of additional learning needs, and it takes them right up to the age of 25. Okay, so it's not only limited to support needed by the young person for education, so it's looking at medical needs as well, possibly social aspects, things like that, and looking just generally at the broader range of support that they might need. So the individual development plan is made up of these key components. They would all include a one-page profile which summarises the strengths and areas of need of the individual, evidence of the action that's proposed expressed using person-centred thinking, an agreed action plan, and names and contact details for all involved in the team. Below you can see a link by Snap Cymru that explains a little bit more about person-centred reviews. So when do we need an IDP put in place? As soon as a learner has been identified as having an additional learning need, the expectation would be that an individual development plan is put in place. Who writes it very much depends on the level of intervention required. For example, a young person in mainstream school who would previously have been supported through School Action, then it's likely to be the ELENCO. For those on School Action Plus, it might also include those already involved in the school and with that child's education, such as the ELENCO and anyone from other organisations who have a role in identifying the type of support or action that needs to take place. If the individual is supported through a statement or has more complex needs, then all of those who have the expertise and involvement with that child would be involved in the IDP meeting, and the local authority would take responsibility for that IDP. So the actual process that takes place is a meeting would be arranged inviting relevant people to that meeting, and before this meeting information about the individual in question is collated. This might include reports, questionnaires and observations. All information must be ready before the meeting. Before or during the meeting, a one-page profile must be created summarising the key areas of need for the individual as well as their strengths. This information then forms part of the action plan, which feeds into the individual development plan. As the diagram illustrates, this is not something that just happens once. Everyone involved keeps on listening, learning and making things happen. Putting the plan into action helps the person to achieve what they want out of life. The plans can be changed or amended as the individual's needs and wishes change, which is why the plan is ever evolving as a response to the individual. The IDP should be reviewed at least every 6 months. but if the team who've put it together agree that it needs to be reviewed more frequently, then they can choose to do this. It doesn't have to be the same frequency each time. It has to respond to the needs of the young person and the nature of the support planned. What is the individual development plan or meeting using a more person-centred approach different from the previous system? Any plan which is developed to support a learner needs to be reviewed regularly to keep up with changes as the person grows and develops. And traditionally, these reviews have been quite formal, maybe only once a year, listening to a range of professional reports describing what has been happening to the child throughout the year. There was also historically very little involvement by the pupil or their parents, and sometimes this has led to things maybe not moving forward, families feeling that they weren't listened to and that perhaps their child's need hadn't been met. So the person-centred review provides a different approach to reviewing plans and planning for the future. There's a clear focus on aspirations and person-centred outcomes. The focus is very much on the future rather than the past, and it includes the learner and their family on equal terms with the professionals. The approach is flexible in that it can be creative, not solely rely on written reports as it was previously done. It might use videos, presentations, photographs or symbols, for example. It can also be as simple as just a meeting between a few people. And however it's organised, it will always be a conversation around the following headings. What do people appreciate about the learner? Has there been any progress or developments on previous actions? What are the learner's aspirations for the future? What's important to them now? What's important for them, i.e. what is their assessed need? How can the learner best be supported? And what's working and not working from the different perspectives of the people involved in the meeting. Just to pause for reflection then, just think about where the IDP process might sit on the ladder of participation. How involved is the child with those decision-making processes? I think the idea is that they are quite involved and their voice is heard, and that the parents' voices are also heard as advocates for their child. And so we would hope it would be high up, a bit higher up at least, on the ladder, but obviously not going to be at the top because it's not something that's come directly from the child. So it's an interesting thing to have a look at. So if you want to go back, have a look at that ladder again and think about where does this new IDP process sit on that ladder of participation. Hopefully that session has been informative in terms of what actual legislation is in place and the issues surrounding discrimination, etc. And also thinking about the current legislation and the new code of practice that will be coming into effect as well. And again, hopefully you've gained some insight into sort of what participation is and how children are able to participate in the new IDP process as well. So as always, here are the references for the material linked to this workshop. Again, if you've got any questions at all about the content of the workshop, then please do get in touch. Thank you very much.